Thank you very much, Ruchiji. Good morning, friends. Subh Shakal to all of you. And I'm really very grateful to my dear learned friend, Dr. Rajendra Anbhule, who is founder president of this your Laws Development Forum, and to my friend, Mr. Advocate Abhishek Jagtap, for inviting me to have an interactive session with you people and to give chalk out a guideline, that you can say sort of a pointers for you people who are interested and keen to clear this AOR Advocate on Record exam, for them enable to be a regular practitioner in Supreme Court, because there is a distinction between what we pass out our LLB programs and then we got get enrolled as a lawyers, and certain group of persons who are especially permitted or authorized after they clear the exam, which is held by the Supreme Court, and they get a what you call certificate to appear to uh, find out to plead in the Supreme Court, submit the documents, which is not permissible to other people, other lawyer friends. Though it is what we call a specialized field for the purpose of a pleading, we say, because otherwise we all are the same fraternity and we are all aware of it. All of us can appear before any of the courts. There is no distinction, there is no bar as such. But the Supreme Court is the apex court from where we have the litigation from all over the country. So for the Supreme Court lawyers who come there, or for convenience of the court, the Supreme Court would itself decided to have a group of lawyers who are basically based in Delhi or regular practitioner in Supreme Court, to enable them to be officers of the court, be a helping hand to the court, as well as to the litigant across the country. And for that, one has to be aware, one has to have a knowledge of each and every aspect of the rules, regulations, pleadings, which you can submit before the Supreme Court. Though the pleadings, which I say before the High Court, before the trial court, may have a generalized form, may have a aching similarity to each other, but there are certain descriptive format, certain things which we have to place before the court in according to the for the purpose of saving the court precious time, as well as the litigants, as well as the lawyers. As we know, Supreme Court is flooded with the cases every day. Every day, thousands of cases are being filed. So for that purpose, we have this advocate on record system. Initially, it was very difficult to crack because to pass out the exam. Most of the people were not that very serious in the profession, which we have seen a distinction from the last, say, about a decade or so, when we have find the people who are joining the profession or people who are keen to join the profession are very much focused, as we all generally know. Earlier, since a general presumption was there, if you are not doing any other profession or any other serious thing, let us join, let us do the law. तुम्हाला सगळंच माहिती आहे, इज नॉर्मली सगळे लोक सांगतात की काय नाही करता, चला तुम्ही लॉ करून टाका. But presently it is not so. Now we have one has to be focused and one has to be serious in the profession to be a successful lawyer, to be having a proper earning source of this your litigation, as well as to give a result oriented case oriented proceedings before the court, be to the relief to the client, be it relief to the your to the court, because at times we see there are several proceedings, several pleadings before the court which are not truthful, which are not properly formatted. The court has really taken a strong view of on the current scenario, and you must be aware of it, that recent judgment which is passed by Justice Bela Trivedi, where she found that the pleadings which was made, this SLP which was filed before the Supreme Court in a criminal matter, which was not even authorized by the so-called litigant, and the advocates and some other person have goofed up the entire thing, and they filed the petition. When it came before the Honorable Court, the original litigant was called, the lawyers from Allahabad and other things were called, but somehow it came up that the lady is not authorized. The court has ordered for investigation in those matter, are asked to register the FIR against the 8-10 advocates, as well as the notaries and other thing. So to avoid all this sort of group of activities which is continuing, we have this advocate on record system, whereby the advocate is responsible, the advocate on record is whole responsible for anything which he put before the court. So it casts out a big responsibility on him. So today, for me to tell you people how to clear, see, we have very short span of time, and we cannot be having a sort of a crash course, but I can, with my experience being in Supreme Court and having that opportunity to clear the AOR exam in the one attempt only, I can give you people a pointers, a sort of a methodology which can ease you to clear this AOR exam. A lot of hype has been built up around, it's very difficult exam, you can't clear and you have to be focused. True, it is correct that yes, you cannot be saying that it is as easy as we do our LLB entrance or our LLB regular course exams and other thing. Even if we are not very much focused, still we go through. But though it's only 4 paper exam, which is basically consisting of 400 marks, but to clear each of them, minimum you have to score 40% in each paper, and aggregate is 60%, without which you will not be declared as a pass candidate. The 4 papers which we generally have in Supreme Court, earlier there was accountancy was also included, but later it has been removed. So presently we have practice and procedure, advocacy and professional ethics, drafting, and the case laws. The, the pattern of the paper is of 3 hour in writing exam. In between, we tried with the Supreme Court tried with doing the what you call computer method also, but that was not successful. But now, which is accepted one, which is continuing, maybe in future something changes that will be different. But as of now, we have this handwritten exams, which is a duration of 3 hours, in which we have to complete the paper. See, the pattern of the paper at times we have seen is certain multiple choice questions, which is called MCQ, or we have a choice of questions between 2 questions are there, which either one we have to attempt, or at times we have about 20 odd questions which has been given, and out of this been given options given for you to attempt 1 or 2 questions become mandatory. Otherwise, you have an option to attempt whichever you feel like. So it every time it depends upon the paper setter or the board of examiners who are appointed by the committee of judges, who are the regular senior advocates who are practicing in court. Those persons set the paper. All 4 papers set by individual persons. At time there can be one person or there can be 2 person who can read us. So it depends upon their mindset, what pattern they want to give for the candidates or for the aspirants to write on the exam. Friends, we all know that it is it is not very difficult to crack the exam, but it is only possible when an aspirant have a clear picture in mind what they want to do. Otherwise, it's seriously a waste of time, I will tell you, with my serious experience which we have. See, what generally a mistake or we do. Let me give you an example. Either of most of us people may be overweight or maybe underweight. We all know, yes, we have to do dieting or we have to follow up this category, these things, routine method to get ourselves in a proper weight for whatever we wish to we have according to age and height and other thing. But how many of us actually follow and routine in a serious manner, in a planned way, do it? It may be, मानू सकते हैं, hardly out of 100, only about say 50-60% which we may start up, but later on it will come down to 10-20% त्याच्या ऊपर वर्क कुणी सिरियसली फॉलो करत नाही. The same manner, we have this advocate on record exam also, and we have aspirants also similar manner, who are very keen to pass the exam, but when it comes for the preparation, they may show the initial keenness, very much keenness to do the preparation. But after certain time, one feel no, it's a routine, mundane routine is not possible. It's a boring thing. They leave it, and they think that last moment आपण जाऊ and ते वर्डला आपण हे सगळं क्लिअर करू, महिनाभर मध्ये वा दोन आठवड्यामध्ये आपण क्लिअर करू. But mind you, friends, is not that so. You have to focus. You have to chalk out for a year or at least for 6 months or so to prepare yourself completely for this exam, the advocate on record exam. Why I'm telling you here, that is what they say, minimum 4 years of regular practice which you have in a court. After that, 1 year of training under an advocate on record who is already having a minimum 10 years of standing. Why the Supreme Court made it mandatory? So that these people, these candidate or the brothers fraternity from the fraternity who want to be a specialized and get this opportunity of being an AOR are aware about the regular procedural part in Supreme Court, the way things to be placed in court, the way to deal with the registry. Because as we say, and we over the period we experience, filing of a case may be easy, but clearing a registry and getting a matter listed in Supreme Court, I'll tell you, it's at least 50% of the major task, major hurdle. Because every now and then they have a different, what you call, formatting or pro forma changing. So you have to be on your toes. You have to be regularly aware of it. So person who is not there in Supreme Court regularly, it may be difficult for him. So that is why they made it mandatory. At least 1 year training under the advocate on record is a must for any aspirant to appear. And generally, the certificate, the advocate who generally gives the certificate is not a formality sake. They see to it, yes, the candidate or the aspirant is regularly coming to his office, regularly doing the work. A regular practice, I mean to say, is not a month or so. It at least you see, first 6 months they may not be that safe, but 6 months they need to be seriously doing that with advocate on record for the purpose of gaining that experience. Now, as we see, if any of the exams we get our students who is doing their LLB degree, or even for the purpose, if you see J entrance people or even the candidates or the students who are appearing in school, why do they perform good? The reason which to my mind generally comes is first thing, they are properly guided, they are regularly focused what to do, the manner in which to do, and they are focused on their aim and goal which they have to achieve. It's not that like a night flare, they walk in and say, नहीं चलो एग्जाम के एक दिन पहले हम पढ़ लेंगे एंड अपन सगळं कंप्लीट करू एंड एग्जाम पास करू. असं नाही होत. We see if those who are not focused for the entire year or the period, they flunk, they don't pass, or they don't achieve good marks even also. We see for the JE aspirant for the years, even from 11, 12 onward, they continue to do their practice, to do their focus to their studies. Same manner in our AOR exam also, we need to remain focused for the entire stretch. I'll tell you, take that year, the training period seriously. And if you are doing regularly, appearing in registry, doing the drafting work, clearing the defects, preparing yourself, drafting out the what you call SLPs or the petitions or the application, whichever is there properly, I make it sure that 50% of your work is done. 50% of your endeavor is done, and you save your 50% of your time for preparation of the theoretical part, because that becomes a practical aspect of it. It gets over. Because this, what I generally say or terminalize is 5 Ds, which is most important, which one has to have for the purpose of clearing is or focusing yourself or putting that endeavor, which I say is your dedication, determination, devotion, discipline, and the direction, along with the consistency, continuity, and clarity for the purpose of cracking or clearing this advocate on record exam. So, my friend, let me move ahead, because you people may say ki, what this person is giving a sort of a lecture which we are aware, which we can focus and do it. So I'll not take much of our time because we have very short span, and we can't dealing with each every paper. But for you people to formalize yourself, to methodicize yourself for clearing the exam, this advocate on record exam, I will let you, I will just formulate a few pointers, and mind it, in this exam, there is no age limit. A person who is passing out your advocate on record, this what you call LLB, having that 5 year, 4 years experience plus 1 year of AOR training, after 5 years, he becomes eligible. And even if you have passed around, say, about 18, 20 years of your practice, still, if you want to give AOR exam, you are eligible. So we have this minimum maximum 5 attempts to clear the exam. In each exam, if you are not able to pass any of the papers, then for the next year, you're not allowed to appear. You have to take a mandatory break. We have regulation 11(1) and 2, which provides relaxation for certain persons who have passed certain papers but may not be able to do the clear the aggregate of 60%. They can attempt choose which paper they wish to do, or in which we have secured less mark for the purpose of making a grade of 60%. As minimum passing in each subject is 40. So if you have not scored any 40 in that paper, that mandatory you have to appear. So now, as I said, we have to have a focus and objective of the purpose of this this clearing your AOR paper. We have this 4 paper practice and procedure, which is 1, advocacy and professional ethics, drafting, and the case laws. Now, how to start for this AOR preparation? Important is you should familiarize yourself. You should take out the last 10 years question papers or 5 years question paper, which is easily available on the Supreme Court website itself. See the pattern in which the topics are being covered up, the manner in which the paper are being set up. So you need to broadly select, categorize, or choose the topic wise, and then for each topic you need to focus the study material, which is not very much, but which is easily available in the Supreme Court itself. The photocopiers are there. From there, we get it. Or last 4 or 5 years, we have seen there are materials which have been circulated on the website. There are the lectures which are being taken by the senior advocates who may be setting up the paper, or otherwise our school, the Supreme Court Advocate on Record Association, at the Supreme Court Bar Association, they organize lectures. And these lectures are also easily available on the YouTubes. I suggest you people to go through those lectures, because this gives you an insight of overall the subject which the examiner tries to cover up within a short span of 1 hour or 2 hours time. They give a brief over idea what he expects, and also I'll tell you, they hint out some part of the questions or topic of which they might be covering in their paper. So it is equally important to attend the 4 or 5 lectures which is being organized by the SCORA 2 3 weeks prior to the examination. This you people can only gaze upon if you have over the year of span of 6 months, 7 months, or a year, prepared yourself. Because last momently, only just hearing the lecture is not going to help us out. Now, for the paper of, as we say, we don't have any fixed syllabus as such for this examination. It is the entire LLB topics covered, which we have already studied. Those are there. Plus the Supreme Court Rules, Practice and Procedure book is there. Supreme Court Rules, which is being amended in 2013. Initially was 1966, which was being followed, but now it's 2013, which is amended and is being followed up. We have a handbook of practice procedure, which is a concise form, short form, because though as we have your in Pune, we are saying most of you are from the Maharashtra and Pune, so we have this Jhabwala and this Pathans, which sort of a Kunji or key guide, which we had at time of this your LLB exams. Similarly, for the purpose of your practice procedure, Supreme Court rules, we have a handbook, which is a concise form which summarizes the entire aspect of the Supreme Court practice procedure, which you can go through, and is very handy. So mind it, which I myself has also done. Make it a sort of a Bible for yourself, that you are reading or you are going through almost every day or alternate day the Supreme Court rules, which itself covers the entire practice procedure subject, and it becomes much more scoring for you, since there are empty number of MCQ or 2 marks on short questions, 2 marks, 3 marks, which you can easily score just like a mathematical examination. You are right to the point, bang on the things, you can easily give the details and answer the points. Because there are certain topics which relates to the power of the registrar, power of the Supreme Court in a chamber matters, power of Supreme Court in a single bench. Because earlier we have this procedural aspect which used to be dealt in the regularly by the division benches or the 3 judge benches. Supreme Court found that it's a sheer wastage of time. So they tried to carve out a single bench or chamber judge, saying that the procedural part of it, taking on record your impediment application, or you call say the transfer petitions, or you may say for the purpose bringing LRs on the legal heirs on the record, and all sort of miscellaneous thing is being under categorized for the power of the chamber judge or even before the registrar, which is accordingly being defined under the Supreme Court rules. And there, by virtue of it, which you can easily read it, aware of it, or even for that purpose, you can say memorize also, because these powers, which are sort of an answer and key point for you to gain marks. So, as I say, this practice procedure is not only a procedural, but also at the same time substantive part of it. Why? Because under this paper, the jurisdictions of the Supreme Court, which is being asked for different jurisdictions, just like advisory jurisdiction, writ jurisdiction, or you say the appellate jurisdiction in the criminal procedure also, or we have this enlargement of criminal appellate jurisdiction of the Supreme Court, whereby the convicts who are being given death sentence and other life convicts, they can directly appeal to the Supreme Court without going for 136, because as we know, Article 136 of the Constitution is your discretionary remedy. It's you pray for leave to Supreme Court to allow you, permit you thereafter. If they grant leave, then it converted this to this regular civil appeal. But under this enlargement of the Supreme Court criminal jurisdiction, there you can directly file the appeal. That is Article 134 also provides the directive filing of the appeal. Then we have a statutory appeals from just like your Consumer Protection Act, or from the SEBI Act, or for that purpose Armed Forces Tribunals Act, AFT Act, or even recently of your IBC provisions, Insolvency and Bankruptcy Code. They also provide to the appeal act to the Supreme Court against the NCLAT order, NCLT, and NCLT goes to NCLAT, NCLAT goes to Supreme Court. So these are not the 136 jurisdiction, but they are directly of statutory appeals which come to the Supreme Court. So as I was saying you, so it is not only the procedure, this paper is not only procedure, but as well as substantive. So we call substantive procedure laws together, it is covered up in this. So in this also, they have this asking for the power of the Supreme Court in criminal jurisdiction as well as civil jurisdiction for transfer of cases. We have this Article 129A, whereby Supreme Court calls upon itself to decide the different cases which may be pending before the High Court, different high courts on a similar point where there may be a conflicting opinion which the court feels either on a petition or even by the suo motu at times call for those petitions to Supreme Court, that is Article 129. Like this, then we have a jurisdiction to appoint the arbitrators as under Section 11 of the Arbitration and Conciliation Act, when there is an international party which is being involved in the agreement between two parties of this tripartite or a four party which is entered into the agreement. That has to come to Supreme Court. So that becomes the original jurisdiction of the Supreme Court. Now, similarly, where there might be a question related to the what is the vacation bench, what is the power of the vacation bench, durations and other things, they can ask for this. Even at times they put up a short questions, sort of on a principle of that stare decisis, obiter dicta, or this sort of legal maxims which are there. So you have to be, apart from that reading your Supreme Court rules and practice and procedure, you have to also have an outline of the regular substantive provisions which are there. Now, similarly, at times the court asks under Article 142, what are the power of Supreme Court, how they can mold the relief. That is very much important. Supreme Court, being the apex court of the country, under 142 has the power whereby, according to their wisdom or discretion, if they want to do a complete and substantial justice to the parties and to put in litigations to the entire thing, which with the parties have continued from the trial court to the High Court and Supreme Court, they can mold the relief. They can even go to the extent of oral request and accordingly modify the prayers of the parties for doing the substantial justice. Then we have the concept of the security petitions, which is only in Supreme Court even after dismissal of your SLP. Then you file your review petition, and still if you feel there was certain justice was not administered properly and still certain point which the Supreme Court has not considered, you need to file a curative petition. But mind my friends, हे तुम्ही लोक जे बघतो की नाही आपण पिटिशन टाकू काय पण होऊ जाईल, that is not correct. For a curative petition, one senior advocate's certificate is mandatory apart from the AOR certificate. Reason being, two of the judges or three of judges have already applied their mind, and after dismissal of your SLP in open court hearing and thereafter review, you are asking them to reconsider the aspect. So the senior advocate who is designated once by the High Court or by the Supreme Court, after they're looking into the abilities and other thing, they give their opinion. What is the point which has not been considered is basically, I'll say, their argument which they will advance before the court in case the curative is allowed and the petition is reopened for hearing. So that certificate matters a lot for the purpose of filing of the curative petition. And it is in the very less cases that Supreme Court interfered. The last recently we have heard with respect to the taxation part of it, it was there, or even for that purpose, we have seen Rupa Shokura. There they laid down the guidelines in what circumstances they can entertain the curative petition or it can be allowed. Similarly, the power of the Supreme Court in the contempt petition under the contempt jurisdiction, that is also one has to be aware of it, which has you may have to go through it. Similarly, there are the questions related to the advisory jurisdiction, advisory nature of the Supreme Court. So these are the basic broad topics which one has to go under the practice and procedural part of it, governed by basically your Supreme Court rules. Now, second one paper which we have is advocacy and professional ethics. My friend, I can be very sure of it that though आपण सगळं exam law clear केलं, LLB clear केलं, we are practicing, but most of us would not have studied this Advocates Act seriously for our knowledge purpose or to have the information which is being there, limitations which is being there, obligation which is being carved out on us in the Advocates Act. We must have gone through it for the exam purpose, either it be it AIB exam, that's All India Bar exam, or our law exams. Because I can tell about myself that I myself had not gone to that time seriously with it. But when I had to appear for this AOR exam, looking at the paper, I made it sure, yes, this sort of a Bible, what you say, or the statute, Advocates Act, it's a mandate, it's a must for me to go through it. So I'll request you people, apart from BCI rules and other thing, the Advocates Act, take it seriously, go through it properly, because this carves out your duties, obligation, which an advocate has to the court, to the client, to the opponent, to our brother colleagues, and their right, mind it, for anything आपण सगळं बघतोय, be it your Delhi, be it your Pune, be it your Bombay, or for that matter recently in your Ghaziabad also, where we see that there was certain disputes between altercation between the judges and the advocates, and the police was made to forcefully take out the advocate from the courtrooms and other thing. And ते सगळे advocate बसलं कसं, strike पर बसले. Now matter has similar thing has come to Supreme Court, and Supreme Court has really taken that very seriously. And that is pending for Justice Oak, sir. He's hearing the matter and he's making it mandatory for the bar associations to file their affidavit that they don't have any authority to forcefully ask anyone to go for a strike or to support that strike. They you have called it. If the person is willing, advocate is willing, they can go support you, but you can't force anyone. He wants to regularly appear for the court for their client. They are bound to, they are free to it. So, under what circumstances, what is the advocate's right to go for a strike? And Supreme Court observation on that, that is equally important because these are the current, recently burning topics which the Supreme Court is going through. So, one, as an AO advocate on record or as an advocate aspirant, you should be aware of the recent topics which is generally going on in the Supreme Court. Nowadays, we have the live law, we have the bar and bench. We give you the insight regularly, saw notes on the Supreme Court happening day in and day out. Similarly, for this paper of advocacy and professional ethics, we have this professional misconduct vis-a-vis the concept of the and the privilege to practice. Then we have this whether the advocate can have the view of the personal weight of the client, whether he can represent or not, or that similar questions will be sort of a questions will be asked whether you can anybody approaches you after committing a murder and confesses before you, whether you can appear or you will have a separate view and you don't want to appear in those matters. As per the Advocates Act, it's mandatory for us because the judges who has to form their opinion, who has to deliver the verdict, who has to judge the situation. It is not you and me as an advocate. We may have our opinion, but we are not the judges. So we have to appear. It's a duty casted upon us. In cases, if we are not liking it, if you don't want to, we may ignore it or we may say, oh, seek an excuse, but it's mandatory under the Advocates Act for one to appear before for the client who has approached him. So as we see, it is advocacy is not basically a craft but a calling, a profession wherein full devotion to duty is required, which constitutes the hallmark and sincerity of your performance and the endeavors so that this profession or the advocacy which reaches to the tower of its success. Similarly, there are the questions asked related to this role of amicus, the jurisdiction of again, we have a conflicting that contempt of court thing up there in the practice procedure part of it, as well as also in the this advocates and professional ethics there also, which is there, where what extent advocate can be held responsible. We have the judgments related to the Rameshwar Prasad Goyal, Vinay Mishra, and other cases which is there, which you can have a list from the Supreme Court from the materials. Now, coming to the paper of drafting, mind you, my friends, ये हम लोग बड़ा इजीली देख सकते हैं कि भाई हम ट्रायल कोर्ट में ड्राफ्टिंग कर रहे, प्लीडिंग फाइलिंग कर, रिटर्न स्टेटमेंट प्लेन फाइल कर रहे, हाई कोर्ट रिट पिटिशन फाइल कर रहे हैं अपन सगळे 226 में 227 में, and we may think that yes, we can easily go through it. We can clear this drafting paper. It's not very tough. It's not very serious to be taken very seriously. But let me tell you, we can't be taking it lightly because this is the paper or which shows the art and skills of the advocate to put in a concise form the arguments of the matrix, some factual matrix of the legal aspects of before the court. We have to have a formulation of a skeleton, what we want to do, looking at the question which is being asked. At times they ask for your counter affidavit, they ask for your drafting of SLP, they ask you for drafting of the synopsis. So considering the question which is there and the regular petitions which is there before Supreme Court, we have to be aware of the specific formats in the civil one, in the criminal one. Let me tell you, earlier the civil and criminal SLP formats are entirely different. in the criminal SLP formats, if you must, people have, since you are preparing for AOR, you must have gone through that. Earlier, the factual matters used to be there in the body of the petition in the criminal matters, along with the marking of annexures and other thing. But later on, after the 2013 amendments and everything, the format is entirely changed. It's the same format as that of a civil one, whereby in the synopsis and list of dates, you put your factual matters, mark your annexures there, and then in the SLP, in the main petition itself, is the question of law and the grounds, apart from the other mandatory paragraph related to the non-filing of the other petitions, or the opening paragraph related to that, under what order, what order you are impugning over here. So at time, the examiners who are well seasoned, who are regular practitioner before Supreme Court, if you lay down their format properly, which is mandatory ones, they are fine. But what they actually look for is the skill of that advocate, the knowledge of that advocate. So your question of law holds a primary field. Your synopsis to be in a concise form holds a primary field for you. To impress upon, yes, you have gone through the topic, you are aware of it, and you can easily do it. And mind you, even with respect to you to aware of it, which are the format for the civil matters as well as the criminal matters, then with the statutory appeals, because in the statutory appeals body, you mark your annexures. In the civil ones, in the regular SLPs, you don't mark annexures in the body. So these are the nitty-gritties which you have to aware. At times, question is being asked, you are not party before the High Court proceedings, whether it still can come before the Supreme Court. One may say, nahi, I was upon the party, not the kai karna upon basu. No, the Supreme Court practice procedure rules provide you. You can file an application for a exemption, for a application for permission to file SLP, and then you can impugn it. Similarly, for the purpose of the, at times they ask to draft is regard to the, because surrender is must before Supreme Court, before filing, before getting a matter listed. They ask for surrender proof. Then you have provision for filing exemption, application for exemption from surrendering, whereby you can move an application to the court, and that matter get listed before the chamber judge, and accordingly they allow you for exempt you from surrendering, or they grant you time for the looking at the matter, importance of the matrix of the matter, and grant order for purpose of surrender, not to surrender, and according matter get listed. So these are the different aspects which you can only gather from the looking at the last 5-10 years papers, the mode and manner of the questions which are being asked. Now, I'll not take, because we are running short of our time. I'm cautious of that. The last paper which we have is the case laws. While these are generally 50-60 cases, which consider 50-60 cases, which are the regular ones over the period which have been prescribed, right from your case from the Bharati and other matters over different heads by the Supreme Court, and they keep on revising year after year, looking at the development, evolution of the law and other things. So these list of the cases are the must which you people have to go. Is you can't choose that one or two question paper, this what you call leading cases which we have gone through, that was sufficient. And this paper is in sort of an open book, this specifically the case laws. As they give you the Supreme Court reports, head notes, it's not the entire judgment, they give you the head notes. But generally we go through the SCC citation or the other general reporters, Martial Law Journal, or upon और दूसरे जर्नल से देख सकते हो which you generally go, but not go through the Supreme Court report. So exam hall में it become difficult. अपन लगा कि कुठं शोधू काय करू आता कुठं काय लिहिलं thinking that yes, it is an open book, I can go and find out and chalk down from there and do it. My dear friend, that's not practically not possible. If you haven't gone through that case laws, it is impossible, I'll tell you, impossible for you to look into the tricky the questions are simple, but the mode and manner in which they are formulated, you have to know the gist of the things what they're asking. You have to look at the heart of the questions, what they're asking for, and accordingly You have to answer it. It's not necessary that you keep on writing a lengthy for like histories or geographies, which we have written in our schools and we scored good marks. No, you have to be concise. You have to know the heart of the question. Accordingly, you have to answer it. So, for the purpose of this case laws, there are basically the method of studying is analytical method, which we say, or the critical understanding of the position of evolution of law, which we have seen. So you need to divide this under different heads or the topics which are there, like your education, service, criminal matter, then related to environmental part of it or constitutional part of it. And accordingly, you prepare a chronology of the subject-wise list and manner of the evolution, the period of the evolution which we have, which it has gone to the subject or the topic which has gone through related to the judgments of the Supreme Court, right from 50 onwards till the current one. And then you can correlate each topics, and accordingly you have your 10 judgments on suppose your uh, constitutional basic doctrine of the basic structure, amendment of it or not, then those judgments can be formulated together. Related to the education, we have this kind of education bill, or we have TMA Pi sort of it. Then you can formulate those under that. Under the content part of it, we have Vinay Mishra, or we have this Rameshwar Prasad Goel, or we have Dabolkar, other thing. Then you can formulate under those different heads. So like this, you can formulate under different heads and correlate e-judgments, and accordingly you can also criticize the judgment when in your answer, which at time people think may not proper, but I'll suggest you, yes, the examiner knows and he looks for these things only. How do you outsmart others? How do you show, yes, you are aware of its topic and these are the pointers which you have gone through, which you have seen, and this is what your point of view. So at times, a dissenting opinion, you should go through the of each and every judgment which they have a dissenting opinion. You should not skip that at all. So, my friends, I'd like to conclude over here with giving you a sort of a 4 or 5 pointers which we have over period. That is, go through the notification which the Supreme Court gives for the purpose of your examination, gather the study material, watch the videos and read the analysis of the case laws in a systematic manner. And important is your writing, because these are 3 hours paper which you have to write a lot. So, and over the period, we all people have stopped writing. Last date was given with respect to that your computer type or computer persons, that somehow there was a glitch, another thing we could not work it out, and accordingly it came back to the writing is the only method which is being there. If in future the changes, that will be later on evolved or later on known to us, but as of now I'm sure it is only the writing. So you people have to practice writing daily, make it mandatory for you. Choose a topic, write at least 10-15 pages, because on in the last or exam is very difficult. We may be aware of the entire aspect, entire knowledge of the paper, we have the everything, but we are not able to complete. Why? There is no speed of us, no, not to complete. So writing is a must. So get into habit of writing. So this is overall the nutshell. I'm sorry we have taken you more time than which was allotted to me, which was given to me, but in
Uh,
short, this I say this
correct.
entire thing.
Yes, yes.